Welcome to this explainer on the foundations of legal research methods, which is literally the exact blueprint you need to build any valid, absolutely undeniable legal argument.
All right, let's dive right into our agenda for today. We have a great progression lined up. We're going to cover methods versus techniques, doctrinal research techniques, empirical research techniques, legal sources and databases, the research sequence, and then we'll wrap it all up with a complete, structured recap. Let's get to it.
Starting off with Section 1. Methods versus techniques. Think about constructing a house. Deciding to build a sleek, modern skyscraper instead of a cozy Victorian home? Well, that's your overarching strategy. In legal terms, we call that your method. It's the broad approach you're taking, like choosing to dig into historical texts rather than going out and interviewing people. On the flip side, the actual hammer or drill you're holding in your hand to piece it all together, that's your specific tool. We call that your technique. It's the exact instrument you use inside that method, like a questionnaire. So, the rule to lock in right now, a method is your broad approach, and a technique is the exact specific tool you use to gather your data. Moving right along to Section 2, doctrinal research techniques. So when we talk about doctrinal research, you're basically working with words on a page. It's text-based. First up, we have the plain reading and interpreting of written laws and treaties. The precise term for this is statutory analysis. Next, imagine trying to wrap your head around something like the law of the sea, which has literally been built up over centuries. To really get it, you have to trace how those rules evolved over time, right? That specific tool is the historical technique. And finally, let's say you want to test an existing domestic law against an international standard it was supposed to follow, just to see if it actually measures up. Testing a law against a recognized benchmark of what the law should be is called the critical or evaluative technique. Again, these are all strictly text-based tools. Now, this brings us to the case law technique, and this requires some absolute surgical precision. Imagine you're reading a massive 50-page decision written by a judge. Somewhere, buried in those 50 pages, is the core essential legal rule that actually decides the outcome of the case. That core rule is the binding law. The precise legal term for this is the ratio decidendi, the binding legal reasoning. But hey, judges are human, right? They might drop in passing comments, throw out hypothetical scenarios, or just make incidental remarks that aren't strictly essential to the final ruling. Those extra little remarks, they're called obiter dicta. So here is the golden rule you absolutely must master. You have to surgically separate that binding ratio decidendi from the passing obiter dicta, because only the ratio decidendi is actual enforceable law.
Sometimes the absolute best way to understand a law is to just put it right next to another one. That's what we call the comparative technique. For example, by comparing India's Admiralty Act of 2017 right side by side with the UK's Senior Courts Act of 1981, we can see exactly how vessel arrest operates in both places, what claims are allowed, and where their frameworks differ. Putting things side by side like this, that is the textbook definition of the comparative technique.
All right, shifting gears to Section 3, empirical research techniques.
Empirical means you are stepping away from the books and gathering data from the real world, lived experience. Instead of reading laws, you might just go and directly watch how events unfold. That's the observation technique. Or you might need to actually talk to the people involved, having structured or even unstructured conversations with folks like seafarers, maritime regulators like DG Shipping, or insurers. Well, that's the interview technique. And if you're trying to understand a massive, highly complex system, sometimes the smartest move is to isolate just one single element, like doing a deep dive into the operations of one specific shipbreaking yard. This hyper-focused, in-depth study of a single unit is what we call a case study.
Now, if you're using survey instruments, we really need to get the terminology exact. If you mail out a survey or blast out a link online, and the person taking the survey fills in the answers completely on their own, that instrument is called a questionnaire. It is literally self-administered by the respondent. But if you, as the researcher, actually sit down with someone and physically fill in the answers on the paper as they speak to you, that exact same set of questions is now legally classified as a schedule. So the rule to remember is, a questionnaire is filled out by the respondent, but a schedule requires the researcher to physically hold the pen and fill in the answers.
Moving into Section 4, legal sources and databases.
Okay, so all legal information out there falls strictly into two categories. Category 1 is the actual enforceable law itself. We're talking the Constitution, statutes passed by the legislature, international treaties, and the actual judicial decisions from the courts. These are your primary sources. Category 2, on the other hand, consists of materials that merely discuss, interpret, or summarize that law. So textbooks, journal articles, law commission reports, or legal encyclopedias like Halsbury's Laws. These are your secondary sources. You always have to anchor your final analysis in the primary text. Which brings us to an absolutely non-negotiable rule of legal research. Let's call it the rigor point. Never ever rely solely on a textbook summary. Think about it. Textbooks and commentaries are written by regular human beings trying to make really complex concepts easier to digest. And in doing so, they simplify things. And sometimes they simplify them incorrectly. If you are doing real research, you absolutely must verify every proposition against the primary source. Restating the exact primary statute or judgment is literally the only way to make sure your foundation is 100% factually accurate. To actually find these primary and secondary sources, you're going to use precise digital databases. And no, you can't just use a basic internet search. You have to match the specific database to your exact need. For Indian statutes and case law, you'll jump into Manupatra, SCC Online, or even the free Indian Kanun. For international stuff, you lean on massive industry standards like Westlaw, LexisNexis, or Hein Online. And hey, if your work is maritime specific, you need hyper-specialized tools like the International Maritime Organization's database, government maritime circulars, or the UN Review of Maritime Transport. Let's bring it all together in Section 5, the research sequence. This is a strict, linear process, and you really shouldn't skip steps here. Step 1. Identify and formulate your exact research problem. Ask yourself, what exactly are you trying to solve? Step 2. Review the existing literature. Dig into both the primary laws and the secondary commentaries just to see what's already been established. Step 3. Based on all that reading, you formulate a really clear hypothesis or specific research question. And Step 4. Select your research design. This is where you decide if doctrinal techniques, empirical techniques, or maybe a hybrid of both will actually get the job done. Moving right into Step 5, you actually go out, execute those techniques, and collect your data. Step 6. You systematically organize and classify the mountain of information you just pulled together. Step 7 is where the really deep work happens. You analyze and interpret that data to find the actual meaning behind it. Step 8, you draw your conclusions, testing your initial hypothesis against the cold, hard facts you uncovered. And finally, Step 9, you write the conclusive report, presenting all your findings clearly and accurately. Let's actually ground this 9-step sequence with a concrete illustration. Let's say your research problem is, how does vessel arrest actually work in India? Well, bringing all our tools together, your research design would be a mix of techniques. First, you'd use statutory analysis to read the 2017 Admiralty Act. Then, you'd use case law analysis to extract the exact holding from actual Bombay and Gujarat High Court arrest orders. Next, you'd use the comparative technique to see how India's rules stack up against places like the UK or Singapore. And finally, you'd use empirical interview techniques, actually talking to real Admiralty practitioners to capture how those arrest orders get executed out in the real world. It's really the perfect harmony of doctrinal and empirical techniques working together. Finally, Section 6, our complete structured recap. Let's lock in everything we've just covered. First, we distinguished broad methods, which is your overall approach, from specific techniques, which are the exact tools you hold in your hand. Under doctrinal, text-based research, we looked at statutory, historical, and critical techniques. Crucially, remember, we learned how to surgically separate the binding rule of a case, the ratio decidendi, from the judge's extra passing remarks, the obiter dicta. We then used the comparative technique to look at India's 2017 Admiralty Act alongside the UK's 1981 Act. Then we shifted to empirical, real-world research, observation, interview, and case study. And we locked down the strict rule that a questionnaire is completely self-administered by the respondent, while a schedule requires the researcher to physically fill it out. Next up, we categorized our materials, cleanly separating actual binding primary sources from interpretive secondary sources. And we heavily emphasized the rigor point. Always verify against the primary text. We cataloged our digital databases, from Manupatra to Westlaw to the IMO. After that, we walked step by step through the rigid 9-step procedural sequence, going from formulating the problem and reviewing the literature, all the way to analyzing the data and writing the report. Finally, we brought it all to life with that comprehensive vessel arrest illustration, integrating statutes, high court orders, and real-world interviews into one cohesive study. I want to leave you with this final, provocative thought.
just to make sure your legal foundation remains absolutely bulletproof as you move forward. If we accept that secondary sources simplify things, and sometimes do so incorrectly, how will you consciously redesign your very next research project to guarantee that you are extracting the true binding ratio decidendi directly from the primary judgment? Think on that. Use these frameworks, apply the rigor, and start building truly undeniable conclusions. Thanks for joining this explainer, and I'll catch you in the next one.